Welcome to the Vermont Criminal Justice Council training and overview on the Vermont Criminal Justice Code of Conduct. This overview will be provided for information on statutory changes, sanctions for on and off-duty conduct, and the expectations for agencies that are required to investigate complaints of unprofessional conduct, as well as officers to understand how violations may impact their certification. So how did we get here? Act 124 of the 2024 session resulted in the addition of a Code of Conduct. The act was signed by Governor Scott on May 29, 2024. It is now legislatively mandated under Title 20, VSA 2371A. The creation and modification of the code, the Council shall create, implement, and modify by rule a statewide policy known as the Law Enforcement Officers Code of Conduct, or Code. This code effectuates the principle that law enforcement officers serve the communities of Vermont and protect all persons against illegal acts in a manner consistent with the high degree of responsibility and respect for human dignity required by the profession. This statute outlines the prohibited conduct that must be included in the Council's Code of Conduct. 1. Criminal conduct, including conduct defined as Category A conduct in Section 2401 of this title. 2. Untruthfulness, including in the course of criminal investigations, in law enforcement agencies' internal affairs investigations, in council investigations, and in matters before a tribunal, and in the preparation, administration, or taking of any official examination conducted by a law enforcement agency of the Council. 3. Misuse of official position, including sexual misconduct and harassment, misuse of property and evidence, solicitation, taking and giving of bribes, and use of electronic criminal records database for personal, political, or economic gain. The prohibited conduct continues with number 4, discrimination and biased enforcement. 5, unlawful use of force while on duty or under the authority of the state pursuant to Section 2368 of this title, including failure to intervene and report to a supervisor observation of unlawful use of force by another law enforcement officer. And 6, domestic violence while on duty or off duty, including attempting to cause or causing physical harm to a family or household member, or placing a family or household member in fear of imminent serious physical harm, or violating the domestic violence involving law enforcement model policy adopted pursuant to Section 2365 of this title. Why did we create a Code of Conduct? Well, the Council members, as well as law enforcement professionals throughout the state, recognized that at times complaints of unprofessional conduct were serious enough for agencies to take action as an employer, but may not have met the current definition of Category B for the Council to take action, such as clear unprofessional conduct, yet the behavior occurred off-duty. So the Code of Conduct was created. 1, to create consistency of outcomes that are not based on individual department policies. 2, to encapsulate the values of and the expectations of behavior for all law enforcement officers in Vermont. And it also provides for Council ability to sanction both on and off-duty behavior and take action on a first offense while simultaneously narrowing and elevating what constitutes a Category B conduct violation, with certain exceptions. To create the mandated Code of Conduct, the Council reached out to members who wanted to work as a working group to take on this project. Many sides were looked at, including labor and management, law enforcement, legal, and outside stakeholders. Membership from this working group included Chief Jennifer Frank of the Vermont Association of Chiefs of Police, Domenica Padula from the Attorney General's Office, Karen Transgard Scott of the Vermont Network Against Domestic and Sexual Violence, Michael O'Neill, representing the Vermont Troopers Association, Commissioner Jen Morrison of Public Safety, Lieutenant Colonel James Whitcomb of VSP, Trevor Whipple of the Vermont Leagues of Cities and Towns, Tucker Jones, who is General Counsel for the Department of Public Safety. Also included in the work group was Kim McManus, the General Counsel for VCJC, Christopher Burkell, representative from the Vermont Criminal Justice Council, Sheriff Mark Anderson of the Vermont Sheriff's Association, Tiffany Reed North of the Office of Racial Equity, and Tom Chenette, representing the Vermont Police Association. This work group also reached out to consultants through the Vermont Department of Labor and the Office of Professional Regulation. So how was the Code of Conduct created? The working group first researched how other states, especially regionally, handle cases of unprofessional conduct. Then the working group utilized IADLIS, the International Association of Directors of Law Enforcement Standards and Training, who run the National Decertification Index, and sought guidance from other states as to how they handle unprofessional conduct. Vermont State Police policies were used as a framework. And then the working group sought input from the Vermont Department of Labor and the Office of Professional Regulation. It's important to understand that the Code of Conduct does not change agency disciplinary process. The Code of Conduct gives agencies clear direction on the expectations for law enforcement behavior. The Code of Conduct applies to every agency. Agencies must still complete an internal affairs investigation, reach a conclusion, and determine what sanction, if a violation occurred, is appropriate based on agency guidelines. Agencies must forward a completed investigation to the Vermont Criminal Justice Council, and agencies can continue to use their own policies. However, if a conflict between agency policy and the Code of Conduct arises, the Code of Conduct shall prevail. So again, as an overview, these are the important highlights for agencies that they need to know. The Code of Conduct applies to conduct occurring anytime, including conduct on duty and off duty unless otherwise specified. Category B offense is redefined in statute. Category B is now defined as a willful failure to comply with a state-required policy or the law enforcement officer's code of conduct. B1 category will no longer exist for violations. The council can take action on all Category B offenses, therefore B violations, even if a first offense, are no longer confidential if the council takes action. Officers will have the right to contest any finding of the council and request a hearing before the council. Additional important highlights for agencies and officers to understand. The council may take action on all Category B conduct, but the council's sanction on a first offense Category B violation is limited. It cannot surpass the disciplinary action taken by the agency unless one of several factors occur. The council's action to a second or subsequent Category B conduct violation is not limited to an agency's disciplinary action. And the council's ability to take action on Category A and C violations remains the same. New statutory language outlined the council's limits on sanctions unless certain factors are met. The new statutory language is found under Title 20, VSA 2407B. First offense of Category B conduct. After a valid investigation of Category B conduct made pursuant to Section 2404 of this title concludes, the council may impose a sanction for a first offense of Category B conduct only to the extent the sanction does not surpass any disciplinary action taken against the law enforcement officer by the law enforcement agency for the same alleged conduct, unless the law enforcement officer is terminated for the same alleged conduct or resigns, the alleged conduct is committed by a law enforcement agency's executive officer, Pursuant to Section 2408 of this title, the law enforcement agency fails to conduct a valid investigation or the alleged conduct or the disciplinary action taken against the law enforcement officer by the law enforcement agency is clearly unreasonable considering the following factors: the nature and seriousness of the offense, the law enforcement officer's job level, certification level, and type of employment, the law enforcement officer's past disciplinary record. The new statutory language continued. The law enforcement officer's work record, the effect of the offense on the law enforcement officer's ability to perform satisfactorily, the consistency of the penalty with those imposed upon other similarly situated law enforcement officers, the consistency of the penalty with any applicable agency tables of penalties, the notoriety of the offense or its impact on the reputation of the law enforcement agency or law enforcement agencies as a whole across the state, the clarity of notice, the potential for law enforcement officers' rehabilitation, mitigating circumstances surrounding the offense, and the adequacy and effectiveness of alternate sanctions to deter such conduct in the future. While it's important to remember that the new legislation provides the Council the opportunity to take action beyond a law enforcement agency's disciplinary actions, it's also equally important to remember what Council sanctions are possible. Generally, the Council may impose any of the following sanctions on a law enforcement officer's certification upon its finding that a law enforcement officer committed unprofessional conduct. 1. The Council can provide a written warning. 2. A suspension, but to run concurrently with the length and time of any suspension imposed by a law enforcement agency with an effective internal affairs program, which shall amount to a suspension for time already served if an officer has already served the suspension imposed by his or her agency with such a program. 3. The revocation with the option of recertification at the discretion of the Council. Or 4. Permanent revocation. After the working group of the Council completed its work, there were several public meetings held. There were informational settings for public feedback. The Vermont Police Academy held public meetings for law enforcement feedback, and the Vermont Chiefs and Sheriffs also held a joint meeting for law enforcement feedback, which ended in September of 2024. The Council then approved the Code of Conduct at their Council meeting on October 2nd, 2024. It is now titled the Vermont Criminal Justice Council's Law Enforcement Officers Code of Conduct. The Code of Conduct starts with a preamble. I recognize the badge of my office as a symbol of public faith, and I accept it as a public trust to be held so long as I am true to the ethics of law enforcement service. In furtherance of these duties, I hereby adopt and accept the following Code of Conduct and understand that this code applies to conduct occurring at any time, including conduct on duty and off duty unless otherwise specified. Untruthfulness. I shall not knowingly make an untruthful statement concerning a material fact or knowingly omit a material fact on an official criminal justice record while testifying under oath or during an agency's internal affairs or VCJC investigation. Discrimination. I shall not engage in a course of conduct or a single egregious act that evidences discriminatory conduct or exhibits bias against individuals based on race, color, creed, national origin, ancestry, sex, gender identity or expression, marital status, pregnancy, religion, age, socioeconomic status, physical or mental disability, medical condition, disabled or veteran status, sexual orientation, citizenship, or any other protected characteristic under law which does not involve an expression of public concern and which clearly and substantially demonstrates that I cannot perform my duties of office in a fair and impartial manner with respect for the rights of others and the laws of the state and nation. Misuse of official position. I shall not misuse my official position for personal or economic gain. Domestic violence. I shall not attempt to cause or cause physical harm to a family member or household member, nor place a family or household member in fear of imminent serious physical harm. I shall not violate the domestic violence involving law enforcement model policy. Unlawful use of force. While on duty or under authority of the state, I shall only use force in accordance with the statewide use of force policy and Title 20 VSA 2368 Standards for Law Enforcement Use of Force, including the duty to intervene as provided therein. Criminal conduct. I shall not engage in criminal conduct as defined by Title 20 VSA 2401-1, Category A conduct. Sexual misconduct. I shall not misuse my official position or use official resources to engage in unwelcome sexual advances, requests for sexual favors, and other verbal, physical, written, auditory, or visual conduct of a sexual nature. Falsification and misuse of property and evidence. I shall not manufacture or falsify evidence and shall not tamper with, conceal, withhold, or without authorization under policy, convert to my own use any property or evidence which has been discovered, seized, gathered, or received in connection with the performance of law enforcement duties. Bribes. I shall not solicit or accept any solicitation or transfer of any item of value for the purpose of influencing my judgment or official conduct. Cheating on examinations. While preparing for, administering, or participating in any official examination either conducted by the VCJC or a law enforcement agency, I shall not cheat or use any dishonest method to obtain, furnish, assist in, or accept or attempt to attain, furnish, assist in, or accept questions or answers to such examination. This code of conduct was adopted by the Council on October 2nd of 2024, and again, the code of conduct becomes effective on January 1st, 2025. We have added what we hope will be some helpful links. Act 124 as enacted, which outlines the code of conduct, the contents, the application and adoption of the code of conduct. The Vermont statute regarding permitted council sanctions, and Vermont statutes regarding statewide policy, the law enforcement officer's code of conduct. Regarding the application of the code of conduct, that is set out in Title 20, 2371, and simply reads, each law enforcement officer, as a condition for obtaining and maintaining certification, shall comply with the provisions of law enforcement officers' code of conduct. Again, this becomes effective January 1, 2025. We encourage any questions that you reach out to us. Let us help guide you through that process, as well as reaching out to your own legal counsel to make sure there is a clear understanding of your responsibilities and for officers to understand the code of conduct that they will be held accountable to. Thank you very much for your time.